Next panel is on SPACs, climate, and ESG, really some of the hot topics in the SEC world right now. Our moderator is Hashemi. He's a chair of the litigation department at Wilson Sonsini, and he has represented companies and boards in more than 100 SEC, government, and internal investigations matters during his career. Also himself a veteran of the SEC Enforcement Division, and he's now practiced at Wilson Sonsini for over 15 years. Look forward to hearing your thoughts, and thanks for leading the discussion today, Kaz. Very pleased to welcome Colleen Keating. She is a senior counsel at the SEC. She's been with the SEC since 2016. Welcome, Colleen. Also with us today is Michael Maloney, a senior managing director at FTI Consulting. He has an amazing background and experience. He previously served as chief accountant of the SEC's Enforcement Division from 2014 to 2018. Also president of Credibility International, a forensic accounting firm. Great to have you here, Michael. And very excited to welcome Kathleen Marcus to this event. She's a partner at Stradling, where she co-chairs the Enforcement Defense Investigation practice and is also herself a former attorney with the SEC's Division of Enforcement. Welcome, Kathleen.
Thank you.
Finally, Kristin Snyder, partner at Debevoise in Plimpton. Haven't been able to say that before for you since March 2022. She's well known at this event. She previously joined us many times when she was the deputy director of the Division of Examinations resident in San Francisco, and she also served for 8 years in the SEC's Division of Enforcement. Welcome to the other side, Kristin, and welcome to Securities Enforcement Forum West. Thank you. Kaz?
All right, thank you, Bruce, and hello everyone virtually and everyone in person. Like many of you, I assume this is my first in-person gathering like this, and it's definitely interesting interacting with humans again. Speaking of humans, we have a great panel today talking about topics that have gotten a lot of attention at the SEC, in particular with respect to rulemaking, SPACs, in March of this year, ESG items, and if we have time, we'll get to some emerging priorities for the SEC. 2021 was certainly the year of the special purpose acquisition companies. We see a lot of activity from the SEC last year. About a year ago, CorpFin issued a statement discussing the need for SPACs to consider books and records and internal control provisions as part of business combinations. In April of last year, then director of CorpFin warned that de-SPACs were the real IPOs for which the SEC should apply the federal securities laws. And then on March 30th of this year, the SEC proposed rules that got a lot of attention, and I'm going to start with Colleen to summarize some of those key aspects of the rules.
So first, a familiar disclaimer that all views are my own and do not necessarily reflect those of the commission or of other staff. So before we get to the proposed rules, I wanted to say a few brief words about SPACs generally. A SPAC is a shell company that allows firms to go public while bypassing the traditional IPO process. The initial SPAC offering raises a pool of cash to be used to acquire ideally a late-stage startup, and the combined entity is publicly listed on an exchange. By all metrics, from the number of SPACs to the dollar amounts raised to the percentage of IPOs comprised of SPACs, the industry has surged in recent years. Using a SPAC to go public can save time and money, and that can be good. It also allows the target startup to negotiate its own value, and that can also be good, especially during times of market volatility. But like most avenues for investing, SPACs can be misused by bad actors, and they have some inherent risks that investors should consider before jumping in. For example, the SPAC sponsors and affiliates may have interests and incentives that differ from those of investors. Turning to the proposed rules, the Commission is taking a proactive approach to responding to developments involving SPACs. The proposed rules would, among other things, enhance disclosures and provide additional investor protections in SPAC IPOs and in business combination transactions between SPACs and private operating companies, often called de-SPAC transactions. They would also deem that a business combination transaction involving a reporting shell company constitutes a sale of securities. They would better align the required financial statements of private operating companies and transactions involving shell companies with those required in registration statements for traditional IPOs. They would provide additional guidance on the use of projections in SEC filings to address concerns about their reliability, and they would address the status of SPACs as investment companies under the Investment Company Act of 1940.
Okay. From a defense perspective, Kathleen, what are some of your key takeaways from the proposed rules? They were certainly long.
Yes, well, I'll just hit on a few. I guess I'd like to start by saying, I think part of what's going on here is bad actors have been sort of drawn to SPACs, and by no means are all SPACs filled with them, but I think the staff has seen a fair amount of bad activity inside SPACs and is causing, they're seeing some of the features of SPACs being exploited, and they're trying to close those loopholes, for lack of a better word. And so you see SPACs are now carrying a reputational risk as a result of what has happened in that particular market. And so I think there's from a defense perspective, a risk just in and of being a SPAC right now. And you see investment banks starting to pull out this week and distance themselves. I think of this as the de-SPACing is really a SPAC target IPO. And so now, all the registration statement that is going to be there and all the disclosures that are going to have to be heavily scrutinized. But one of the more interesting features that I think we should all pause and consider what the ramifications are going to be is this idea that boards now have to consider the fairness of the transaction. And on one hand, that might be like, okay, well, they're going to have to go get a fairness opinion and really consider that. But the details of that are going to be really important. What is that going to look like? What kind of information is going to be in that fairness opinion? Are there going to be future projections in there? And with the hindsight of 2020, after the transaction closes, people are going to be looking and exposes these board members to greater liability as to what they did in that process when they weighed in.
What do you think of the exclusion from the safe harbor for forward-looking statements as part of the proposed rules?
Yeah, so this is also really important, and I actually think it can be related to the fairness issue that we just talked about. So just by way of background, I'm sure this room is well aware, we're talking about the safe harbor for forward-looking statements, which is normally protected as long as it's coupled with the proper cautionary language. But IPOs are excluded from that safe harbor, as are blank check companies less than 5 million. So those SPACs that were over 5 million enjoyed that protection. And as part of that, you would see SPACs commonly having performas, for example, whereas IPOs that you don't see performas regularly in that setting. And that's important because now you're taking, and some commentators are saying, okay, well, that just means now if SPACs are supposed to be more, or de-SPACing is supposed to be more like an IPO, then you're just going to see less of those forward-looking statements. They're not going to see performas, and that will have this unintended effect of investors having less disclosure. But I actually think that in certain situations, it's maybe going to be more complicated than that when it's coupled with this idea of this fairness opinion, right? Because, and if you'll just bear with me, I think there's a couple steps to this. So if you're on a board and you have to rely on fairness, and then you say, okay, well, what's in your fairness opinion? My fairness opinion contains projections and an outlook and to what the company is going to ultimately be. And now I have a blue sky rule, let's say, that says that the information that I relied on has to go into my disclosure. And so you're like, okay, well, wait a minute. Now I have to maybe disclose my projection even though I didn't want to, and I don't have a safe harbor. So it may actually force the hand of certain SPACs to disclose projections, and they're naked in the safe harbor area. So
it does impact how do we advise companies on projections moving forward in light of these proposed rules?
Well, I think it's really going to put SPACs in a really tight spot because, on one hand, there also is a ton of market pressure, right, to put out forward-looking statements because you say, okay, well, I don't want everyone to redeem, so I want them to stay in, and so I need to show them what they're investing in, what the future is going to look like, so there's pressure there. The bespeaks caution doctrine, which the PSLRA is based on, would presumably still be there, but it's not clear because that was, is what it was codified from, what's going to last. And I think one of the practical ramifications that you're going to see is that target companies that don't have a long, robust operating history are maybe going to become less attractive as SPAC targets, because now you're going to be in a place where you're in a more speculative area and you may be forced to do the projection.
And Kristin, what are your thoughts on the proposed rules? And there was a strongly worded dissenting opinion by one of the commissioners that perhaps the audience would be interested in.
Yeah, so I would echo a lot of the same points that Kathleen made, and it's really weird for me not to do the standard disclaimer. It hasn't been that long since I left.
You can, you're free to.
No, I don't think I will. No, it's kind of nice. But I thought, I can kind of start with where the kind of cleverly titled dissent that Commissioner Peirce put out, and then that frames some of the issues that I think we're talking about as well, some of the issues that are being raised regarding the proposal. And so I think, Commissioner Peirce raises a number of points, including the legality of the proposal, concerns around the legality of the proposal, as well as imposition of kind of substantive requirements on SPACs that she believes is going to sort of chill the marketplace. So she makes the point that, we've already seen a decline in the number of companies going public, sort of through direct listings or the general IPO process, and raises concerns that this is going to, we saw a robust SPAC market, that this is going to chill that SPAC market. So that's kind of first and foremost, and sort of overlays a lot of her commentary. But just in terms of the legality, she makes the point that the typical SPAC really isn't operating kind of within the framework that's being kind of contemplated through the proposed rulemaking, and lays out a few different requirements I think that the proposal has that would significantly add to the burdens and the costs in terms of completing a SPAC or launching a SPAC. So I thought I would just cover a few of those. I won't go through the whole thing. But in her view, I think the proposal's elimination of the PSLRAs, and she does view it as an elimination of the PSLRAs, safe harbor was done through what she calls a regulatory sleight of hand. And she makes the argument that it was contrary to what Congress intended, and sort of redefines what a blank check company is to remove the penny stock condition. And that's something that Kathleen mentioned just a moment ago. And she also takes issue with the idea that there's a non-exclusive safe harbor that's now put in place to take us back out of consideration of being an investment company as long as certain conditions are being met, and really raises the point. I think some of it, we've seen a lot of press around some very prominent SPACs that ran into Investment Company Act issues, kind of earlier in the year. And so that non-exclusive safe harbor may be sort of designed to address that in light of some of the circumstances that happened there. But I think the point that Commissioner Peirce makes in her dissent is really blank check companies have been around for a long time, and there hasn't been, up until recently perhaps, investor confusion or issuer concerns regarding operation as an investment company. So are we essentially just putting additional conditions, on SPACs, and again, making it more difficult for folks to actually want to use those as a vehicle to take companies public? So I think, I'll stop there because I know we have a lot to talk about, but, a number of different conditions that I think are really going to cause companies to have to think carefully about whether they want to use this vehicle. And if so, to Kathleen's point, thinking very carefully about whether you want to include projections. And then last but not least, I was going to give some statistics. I think Mike Dickey mentioned it on the first panel of the day. There's a lot of shareholder litigation that we're seeing now focused on SPACs. So something else for folks to keep in mind.
Yeah. Mike, let's get you in here as the former chief accountant for enforcement. What are some of the key takeaways for you from the proposed rules?
Yeah, well, I'm cognizant of it being the 2:30 coffee crash hour, so I'll stay away from technical accounting as much as I can. But Colleen mentioned that one of the objectives of the proposed rule appears to me to be to align the financial reporting requirements of SPACs to a traditional IPO. And some of the more detailed things in the rule relate to, which financial statements need to be presented, the age of financial statements, codifying existing guidance about the need for the target company to have a PCAOB audit. And then maybe the most complex area relates to SX Rule 3-05, which relates to the application by the target company of that rule, which has to do with whether or not you need to provide standalone financial statements related to companies that are acquired. And so I think that's something, and it's a percentage, it's a numerator denominator that gives you a percentage under various tests. And if you're over a certain threshold, you have to include those financial statements. And I think the biggest change is the denominator there now relates to the target company. I think that's a bit of a change. That's a really complex rule. And so all of those things lead me to an overall point that I see in this rule, which is, advanced planning through the SPAC and de-SPAC process of really thinking through and trying to anticipate which financial statements you're going to need to have in the filing, which ones are going to need to be audited, and all of the work that needs to happen in advance to get that done. I think that's one of the things that jumps out for me. And I think that also the broader point, which is not necessarily related to this proposed rule, but generally that what I call the ready for prime time kind of aspect of SPACs, which is for a lot of the target companies, which are perhaps less sophisticated companies from a controls perspective, is again doing, and I know others have made this point for the last year, doing all that work well in advance to do the best you can to have good solid controls. You're going to be under audit, and then you're going to have to report on those controls pretty soon. And then real quickly on the warrant guidance, that came out in April, about a year ago, in April of 2021. Just a couple of quick things about that. It was a joint statement by Corp Fin and OCA, which to me, in and of itself, is kind of unusual to have those two issue a joint statement. Essentially, and many in the room may know this, that guidance was about whether warrants need to be classified as equity or as liabilities. And to just cut to the chase, if it many SPACs were, they were shown as equity. If they're shown as liability, they need to be fair valued, and that has to be happening every reporting period. And if there are changes in that fair value, it goes through the income statement. And so, in the simplest terms I can put, that's really the upshot of if it changes to liability treatment. And so obviously there was a lot of scrambling around that. The staff was very clear to say these weren't new rules, and they weren't, but they were giving their take on what existing GAAP required. And so there were a lot of restatements. I saw published that there were over, by July of 21, so a few months later, there were over 300 big R restatements and over 200 little r revision restatements, which means an error but not material. And so one of the things that's interesting to me on that point is, I always think about potential regulatory activity and enforcement activity. There are a lot of restatements. These are mostly balance sheet issues. Will those attract scrutiny by the staff, by the enforcement staff? And if they do, will they be an opening way to open an investigation? And then once the staff is doing that investigation, is there potential that those investigations could expand to other areas of the reporting? That's just me, and it's just complete speculation. But because there are so many restatements, and restatements often trigger interest by the SEC enforcement group, that's something I think to keep in mind.
Well, it all sounds very attractive if it becomes effective. So there was an enforcement action that got a lot of attention last year. The SEC brought an action against the SPAC, its sponsor, its CEO, SPAC's proposed merger target, Momentus, and Momentus's former founder and CEO. Stable Road and Momentus was the case. So Colleen, can you summarize it for us?
Sure, yes, and as you suggested, we charged all sides of this SPAC transaction based on misleading claims and inadequate due diligence. So as the commission said in its settled order, investors were repeatedly told that Momentus, the target, had successfully tested its propulsion technology in space, when in fact the company's only in-space test had failed to achieve its primary objectives or to demonstrate the technology's commercial viability. The commission orders also found that Stable Road, the SPAC, repeated Momentus's misstatements in public filings and failed its due diligence obligations to investors. So I think this case illustrates the risks inherent to SPAC transactions, because those who stand to earn significant profits from a SPAC merger may conduct inadequate due diligence and mislead investors. It also reinforces that SPACs raising investor funds are critical gatekeepers who owe investors a duty to properly fulfill their due diligence obligations. Stable Road, its sponsor, and its CEO failed this duty while placing themselves in a position to profit from the merger and to monetize on investor interest in the SPAC. And lastly, it shows that all parties involved in a SPAC transaction can face liability if they do not adequately adhere to the securities laws. So here, one party's lies to investors and its merger partner did not absolve the other party's responsibility to conduct due diligence to protect shareholders.
And then the remedies, there were some interesting remedies in that case.
Yes, so the commission obtained significant relief for the benefit of investors. First, Momentous and Stable Road agreed to provide PIPE investors termination rights, which means that they have the opportunity to redeem their investment if they choose to do so. Retail investors will know what the PIPE investors decide to do before they vote on the merger. The SPAC sponsor agreed to forfeit 250,000 founder shares that they were entitled to receive upon shareholder approval of the merger. Momentous agreed to undertakings requiring significant enhancements to its disclosure controls. And Momentous, Stable Road, and the CEO paid a collective total of more than $8 million in penalties. And the commission's order establishes a fair fund for the benefit of harmed investors. So by requiring the sponsor to relinquish its founder shares and imposing strong undertakings on both companies, this case demonstrates that we will prevent wrongdoers from benefiting at the expense of harmed investors and will seek to align the financial incentives of SPACs with those of ordinary investors.
And then there was a one at the end of last year, I think it's pronounced Akazu. Can you just quickly review that?
Yeah, sure. So in Akazu, this entity claimed to be a rapidly growing music streaming company with millions of paying monthly subscribers and more than 120 million in revenue. But in reality, as Akazu subsequently admitted in a public SEC filing, the company in fact had no paying users and negligible revenue at best. So after the business combination, Akazu began trading on the NASDAQ and proceeded to defraud retail investors by misrepresenting that it had earned tens of millions of dollars in 2019 and increased its paying subscriber base by 28% year over year. But in reality, the company continued to have limited operations, no subscribers, and marginal revenue, all while depleting more than $20 million of investor funds. So we filed an emergency action to obtain an asset freeze to preserve the company's remaining $31 million in cash and assets for the benefit of harmed investors. And in October of last year, we announced a $38 million settlement.
So Kathleen, Kristin, as defense counsel, does this impact how you advise clients, or are these just one-offs? How do you view these enforcement actions?
Are we allowed to say buckle up?
Buckle up.
I don't have a crystal ball here, but I think you're going to see a lot of activity, and I would think you're going to see it both on the target side as well as the sponsor side.
No, I would agree with that as well. I think it's it's a listed priority both for the exam program, for enforcement. So I think we'll see it on all sides.
Right. All right. Well, we're going to change gears here to climate, environmental, social, and governance issues. Obviously, it's important to all of us, and it's gotten the SEC's attention as well. They proposed rules again in March of this year that got a lot of attention. I think the client alert departments of law firms got very excited. In a couple of weeks, they were issuing a lot of alerts on these new proposed rules that were coming out. So could you quickly summarize those for us,
Sure,
Colleen,
yeah.
and then we'll turn it over to our
I'll
defense
try to do
counsel.
it quickly. Yeah, it was another lengthy proposal. I think it was around 500 pages, so I'll try to just really briefly summarize the proposed rule amendments. In essence, they would require registrants to include certain climate-related disclosures in their registration statements and periodic reports, such as Forms 10K, including the following: how any identified climate-related risks have affected or likely to affect the registrant's business strategy and outlook, the registrant's governance of climate-related risks and relevant risk management, the registrant's greenhouse gas emissions, certain climate-related financial statement metrics, and information about climate-related targets and goals and transition plan, if any.
Kristin, from a defense perspective, what are your key takeaways, and how are you going to advise clients on these rules moving forward during the comment period and beyond?
And again, I think I have the same issue that Colleen does. I'll try to be succinct, but there are a lot of things to consider, I think, given the proposed rule. And the comment period is still open, so it is a proposed rule. It may change. It may change around the edges, I think, through the comment process, and that's certainly the hope, I think, in certain areas. But the rule proposal, I think the commission did try to align many of the recommendations to the TCFD and the greenhouse gas protocol. which many companies, may be complying with already, or, that was at least the hope. When you dig into some of the studies, though, I think in terms of TCFD, it is a small but growing number of companies maybe that are applying that protocol or that framework. So I think starting early, getting your arms around the proposal and the requirements early is going to be really important. There is a phase-in period for the various requirements based on the company size, and smaller reporting companies have less requirements than some of the larger companies. But again, it's a sea change in the sense that we're going from kind of soft law in this area to much more prescriptive requirements. And I think globally, we've seen that happen as well. So I think there are a number of foreign jurisdictions that are kind of ahead of where we are. But again, I think very important, with this kind of transition, to be on top of things early and really paying attention to what that's going to mean for your business. And I think one of the bigger areas of consideration for companies, there's a requirement that scope 1, 2, and 3 emissions are going to have to be reported for certain.
Can you explain what those are?
I'll try. I will try. And then, Colleen, you can correct me if I get this wrong. But scope 1 is sort of direct emissions that a company might emit. Kind of your. Scope 2 is indirect, so it's electricity that you might use to power your business. And then scope 3 is kind of everything else. It's your supply chain, it's employee travel, it encompasses a lot. And I think it's very hard to measure. And so for those companies, there is a safe harbor, and there's a requirement, at least for a period of time, for scope 3 to only have to be reported so long as the company is making disclosures on it and is viewing it as a material, part of its disclosure. But it's a little bit of cold comfort, because I think there could be real foot faults, in this area. And so I think, again, companies will have to think carefully. There's also an attestation requirement that's, very, very similar to an audit. I think we'll see a cottage industry grow up around, this attestation, kind of function that's going to happen with the scope 1, 2, and 3 emissions, or at least scope 1 and 2. But again, I think starting early, really paying attention and kind of looking at compliance programs within, the company, how reporting is being undertaken, and being very careful in that reporting, not kind of overselling or overstating what's being done.
Do you think it's, as you've spoken with clients and companies, that it's the rules bring clarity on what companies should do, or do you sense confusion about how we're going to comply with these proposed rules if they become effective?
I think, maybe my Pollyanna view of the world, maybe I think there's a hope that it'll bring some sort of consistency, reliability, and just comparability, across companies. So from an investor perspective, that may be helpful when comparing company to company related to climate-related risks. But I do think there's still a lot of things that could be clarified, perhaps through frequently asked questions or through the comment process. For instance, one aspect of the rule explains that the company needs to disclose its climate-related risks over sort of the short, medium, and long term, but then that's left open, and then the issuer gets to decide what's short, medium, and long term. And again, you could see that as an area where there might be a foot fault if there's second guessing as to whether that was short, medium, or long term was reasonable.
Right. That's a good example. Kathleen, once again, there was a commissioner that issued a strongly worded dissent. Would you summarize it for us and provide any thoughts you may have on it?
Sure. So, surprise, surprise, it was Commissioner Peirce again, and it's a very lengthy dissent. But I'm just going to hit the highlights, and really there's I think two overarching themes in her dissent. The first is she basically, at least my interpretation of it is, hey, we had a grand bargain here at the SEC to be focused on financial disclosures. And this particular set of proposed regulations is more about socially or reputational issues, which might be important to investors, but that strays from our core mission and what we're doing. And then the minor sort of, that'd be the major concern. I think she has the minor concern that flows through all her points is, hey, this is an area that's not uniform and disparate. And although there's been ties to a lot of different ways to look at this, it's still kind of in the cake is baking stage. And so it's going to cause it's going to cause a lot of just complete lack of uniformity from company to company. And what will that really mean? And how valuable will that be for investors? So I'm just going to quickly tick through some of her major headlines here. She believes that the existing rules already cover climate risks that are material. She thinks that scope 1 and 2 emissions do not have a materiality qualifier, and that the materiality qualifier for scope 3 is either sort of illusory or presumed to be present. Then again, what I just mentioned with respect to how measurable is this. And she lists some really interesting ways, a good sort of laundry list of things that companies will have to think about. So I'm just going to read them for you here. She's like, okay, companies are going to have to speculate about the habits of their suppliers, their customers, their employees, changing climate policies, regulations and legislation, technological innovations, adaptions, and changing water patterns. And I found that list to be a little overwhelming when I thought about it. And she also raises the point, like, okay, so if you are gathering information from your suppliers and you have two suppliers that have roughly the same process, what do you do if they give you wildly different answers? How do you incorporate that, and what's reliable? She also questions the legal authority that the commission has, including First Amendment. And then finally, questions about is the cost wildly underestimated from what is thought to be what companies are going to have to take on.
Right. Some could interpret she laid the groundwork for a First Amendment challenge to the proposed rules in her dissent. So that's interesting. Mike, putting your accounting hat on. Well, I guess you always wear your accounting hat.
Yeah, I just didn't wear it today. I left it back east. Yeah. So
what's your perspective, and what do you think it does to the financial statements and auditing?
Yeah, I think there's really, if the proposed rule went through as is, there's been a lot of focus on the scope 1, 2, and 3, which, as Kristin mentioned, is also subject to attestation, but probably not by the firm's regular auditors, probably by a specialty firm. But what really took me, really focused me when I looked deep at the requirements in the rule are that within the financial statement footnotes, there is so much information that's being called for, and I'm going to go through it really quickly, but financial impact, expenditures, and the impact of those items on the company's estimates. Within financial impact, there's climate-related events, and then there's transition activities to lower the carbon footprint. What is really striking to me is all of that information needs to be disclosed in the footnotes of the financial statements in terms of its impact on every line in the financial statement. So it's a line-by-line analysis on those categories going through each line in the financial statements unless it's less than 1% of that line item. To me, that's a sea change. I can't think of any current requirement that requires a disclosure of an issue on every line of the financial statements. And so I think, and so all of that information not only needs to be disclosed, it needs to be audited by the company's auditors, as well as the ICFR, internal controls over financial reporting, around those issues needs to be assessed by management, and then the auditors audit that assessment. So I actually analogize just that part of the proposal, and maybe this is a little exaggeration, but really in the same league as the adoption of a really significant new accounting standard. So think about revenue recognition, ASC 606, or when SOX came into being and all the internal control requirements. In terms of the amount of work that a large company would have to do, will have to do to get ready to disclose that information. You start to think about, in terms of, and working with the auditors to be able to audit that information. And I note that I think for the large accelerated filers, as written, this requirement would be effective for fiscal year 2023. Companies were preparing for years for ASC 606. And so, maybe all of that will shift a little bit as the proposal gets finished. But so in terms of advice to companies, it's the same thing. It's, do your best to anticipate what this proposal is going to look like at the end, but start getting ready. And a lot of it's going to be data. It's getting the data out of your company and out of your systems that will allow you, companies are going to have to automate this kind of process in order to prepare the financial statement disclosures that are required. Start planning with the audit committee and the board and with the auditors. Start talking about this now because I think it's probably likely there's going to be some requirement left after the proposal is finished in terms of what needs to be in the footnotes and what needs to be audited.
What do you think the auditors are going to do to audit this? I mean, other than putting another item in the management rep letter, I'm sure.
Well, on one hand, I think they're happy because they're going to have a lot more work to do. But on the other hand, look, I think, the information in the footnotes, people kind of forget about that. It's always about the financial statements. I think the auditors are just going to have to work like they would on any other substantive issue and get the data underneath it and figure out how to test it. There could be a lot of data that rolls up into this. So I think, all of that is going to, really take a lot of time. One other thing I'll mention is I think it's always instructive to read the questions that they propose for comment to the public in these things. And one of the questions was, should we require, because of the amount of this information, a brand new financial statement, meaning the financial statements would now look like a balance sheet, an income statement, a cash flow statement, and a climate-related financial statement. So if that's not a sea change, I don't know what is. That's a whole new, it's been those three financial statements forever. Now that may not happen, but the fact that that question was answered, to me, demonstrates how significant these changes are.
Yeah, sounds like it. Are you going to comment on it during the comment period?
Me personally?
Yeah.
Not yet, although maybe I have a little time. Right?
Okay, yeah, kind of extended. All right, we have 9 minutes left. So we're going to move on to emerging enforcement priorities, just so we have enough time to capture that. I know the chair has repeatedly said private funds are a priority for the commission. And I don't think there's much discussion happening today on private funds. So I think they also proposed some rules earlier this year on this topic. So Colleen, why don't you give your perspective on this, and then we'll turn it over to Kristin.
Yeah, so from the enforcement perspective, we're committed to protecting investors in these funds. There's been significant growth in the private funds market, in particular in private equity and venture capital. And the unique features of private fund investment lend themselves to recurring issues involving conflicts of interest, fee and expense allocation, asset valuation, and controls around MNPI. So with respect to fee and expense issues, we continue to scrutinize private fund advisors' management fee calculations to ensure consistency with the fee approach that's disclosed to fund investors. In our work investigating valuation of private fund assets, we continue to analyze whether advisors or advisory personnel responsible for valuation are valuing fund assets consistent with disclosures, and whether they are manipulating valuations by, among other things, obtaining fraudulent broker quotes or making improper changes to valuation models. And finally, with respect to material non-public information, we will look at whether advisors who are likely to obtain such information have adopted and implemented the necessary policies to ensure that they do not illegally profit from trading on that information.
Kristin, I think people would love to hear your thoughts on this now that you're on the defense side.
On the other side, yeah, there's a lot going on with private funds.
Yeah.
So on the regulatory side, I think it's not surprising, and as Colleen mentioned, there's been an incredible growth in the private fund, market. So I think some statistics have been thrown out. I think we're now at 18 trillion of assets under management managed by private funds, and that's a roughly 70% growth over 5 years. So again, makes sense as to why the commission is focused on this area. And it's not that there wasn't a focus before, but I would challenge you, if you go back to 2018 and 2019 and look in the exam priorities, you don't see the word private funds. It doesn't mean that private fund exams were not going on. It's just that it wasn't, I think retail investors were clearly a focus under the past administration.
What were you doing in 2018?
A lot of retail exams, but a lot of private fund exams too. Just wasn't in the priorities. But I think, again, given the growth in the marketplace and the chair's clear priority on the regulatory front, there have been expansive private fund rules that have been proposed with very clear and prescriptive prohibitions on certain aspects of really the economics of the deals that private fund advisors can enter into. And that to me, I think is a bit of a sea change, is going from a relatively principles-based approach on the Advisors Act to a much more prescriptive approach. So that's new and different. And so I think it's natural, that's the chair's priority on the regulatory front, and kind of flowing from that, there are both exam and enforcement priorities related to private funds. Private funds featured first in the exam priorities that were published in March of 2022, so it's a clear priority. And I think the private funds unit, as well as the enforcement staff, have really become much more sophisticated in their approach and their understanding of the private funds market at the SEC. And so you see, a deeper dive into the areas that Colleen mentioned. So on the fee and expense side for private equity, I think there's a real focus on post-commitment management fees at private equity firms right now in varying forms. And so I think, we're seeing on the defense side as well as, in the priorities that are published by the Commission, a focus on how firms are calculating those fees, how assets are being valued, whether the firm's documents talk about whether it's in the limited partnership agreements or operating documents, if there's reference to write-offs or write-downs, the exam teams, I think, are really cluing in on those topics and asking a lot of questions and making some, asking questions around the reasonableness of when certain assets are being charged off and then flowing through to management fees. So that's just by way of saying, I think, there is a focus. I think the Commission staff is asking very sophisticated questions in this space. So in the private fund, sector, I think it's really important to be prepared and really be looking at your disclosure documents kind of against what's happening in practice.
Do you see a sea change in the number of enforcement actions coming in next year in this area in light of the chair's?
There's likely an appetite for more private fund. We've seen some private fund cases come out. The conduct, that it takes a bit to investigate, and so some of the conduct that we're seeing is from several years back. But I would expect, kind of with the increase and uptick in focus in the exam program, many enforcement actions are resulting from enforcement referrals from the exam program. So I would expect that we would see, an increase in private fund matters.
Mike, any accounting thoughts on this?
Yeah, I would just say it's all about valuation and impairments from an accounting perspective. And in my own experience, whether it's private funds or not, but if it's funds and they've got valuation issues, the staff will not hesitate to go deep on those issues, challenge assumptions. And then on impairments, of course, typically the timing of impairments. I've seen a lot of aggressiveness in a lot of cases by the staff. And so those can be tough cases on both sides to really debate what are at their core very judgmental issues. But I would not expect that to decrease. I would expect it to continue and probably increase.
Great. One last thing. The last topic we'll talk about is with Kathleen. I'm sure there's been discussions today about the Wells process and the remedies that perhaps may be coming in terms of admissions and the differences they're doing in the Wells process possibly. You interestingly had a recent example that I think the audience would benefit from hearing. Because I had not recognized it when it happened, so.
Sure. So I'll share something. There has been a lot of talk about admissions today, and I had an experience recently for a matter that has now been filed and is public that is sort of what was the staff referred to as a hybrid situation. So it was initially a no admit, no deny when we began talking about resolution, but it turned into just a no deny. Not an admission, but it's just silent as to admission, and it's just a no denial. It has all the same protections that a no admit, no deny would have with respect to there's other proceedings going on. It only applies to the SEC matter, right? So if, God forbid, the criminal authorities do decide to pursue him, he will be able to move ahead and testify appropriately with respect to that. But I was assured by the staff that this is something that's been going on for 6 months, but I have yet to meet another staffer who knows what I'm talking about. So I think it's new, and so I'm sharing it with all of you here that it's a thing, at least that's being tested. So.
Do you think any pitfalls for the silence? It's, as you say, it's not an admission.
Well, I'm not really sure what courts are going to do with it. Is part of the problem. It's in a little bit of untested waters. So I only proceeded because it had that same language that in other proceedings he could testify, and so it only applies. And so I'm not really sure where the teeth are going to be for it, but I'm very uneasy because it's such a different position than I've seen anywhere else. And when the complaint was filed and everything came out, no one else picked up on it in the press either. So it's so subtle, but I just wanted to share it.
Well, Colleen, Mike, Kristin, and Kathleen, thank you so much.
Thank you, Kaz. Thank you, panel. Great job. All right, we'll be back in 10 minutes.